नमस्कार दोस्तों, अगर आपका बिज़नेस B2C कैटेगरी में है, मतलब आप डायरेक्टली मास कंज्यूमर्स को अपनी प्रोडक्ट या सर्विसेज को ऑफ़र करते हो और बेचते हो, तो देन यू मस्ट अंडरस्टैंड द इम्पोर्टेंस ऑफ द ऑर्डर्स पास्ड बाय द सेंट्रल कंज्यूमर प्रोटेक्शन अथॉरिटी। अगर ये ऑर्डर आपके फेवर में नहीं है और इनफैक्ट प्रॉपरली आपके अगेंस्ट में ही है, तो देन उस ऑर्डर के अंदर आपको पीनल प्रोविजंस को भी इन्वोक किया जा सकता है। इस वीडियो के अंदर आई विल टेक यू थ्रू, अगर आपके अगेंस्ट ये ऑर्डर पास हो गया है तो आप CCPA का ऑर्डर कहाँ पे अपील कर सकते हो, कौन सी कॉम्पिटेंट अथॉरिटी के पास आप अपील अगेंस्ट दी CCPA ऑर्डर फाइल कर सकते हो। I will discuss the timeline of filing an appeal before the competent authority. I will also discuss कि grounds of appeal हमारे क्या होंगे। इन सभी बातों को ध्यान में रखते हुए let us now get deeper into the appeal process against the order of the CCPA, that is the Central Consumer Protection Authority. हमारे पहले क्वेश्चन का आंसर है कि अगर आपने CCPA के ऑर्डर को अपील फाइल करनी है, द कॉम्पिटेंट अथॉरिटी इज़ ऑनरेबल NCDRC, नेशनल कंज्यूमर्स डिस्प्यूट्स रिड्रेसल कमीशन NCDRC। ऑनरेबल NCDRC के पास जुरिस्डिक्शन है टू एंटरटेन द अपील अगेंस्ट द CCPA ऑर्डर। ये आपकी इन्फॉर्मेशन के लिए इम्पोर्टेंट है कि जो CCPA है वो वेरी रिसेंटली इंट्रोड्यूस करी गई है अंडर द कंज्यूमर प्रोटेक्शन एक्ट 2019 में। CCPA का प्राइमरी पर्पस ये है कि जहाँ पे भी कंज्यूमर्स एज ए क्लास के राइट्स इफेक्ट हो रहे हैं, तो देन CCPA विल आइदर टेक ए सुओ मोटो एक्शन और विल टेक एन एक्शन बेस्ड ऑन द कंप्लेंट filed by a consumer not for his personal benefits but for the consumers as a class। तो जहाँ पे भी कंज्यूमर एज ए क्लास के राइट्स इफेक्ट होंगे, यू कंसिडर CCPA विल गेट एक्टिव। एंड दैट इज़ वाई अगर आप B2C की कैटेगरी में बिजनेस ऑपरेट कर रहे हो, चाहे आप प्रोडक्ट्स बेच रहे हो, गुड्स बेच रहे हो या सर्विसेज बेच रहे हो, तो देन CCPA इज़ गोइंग टू कम इनटू योर वे अगर आपकी सर्विसेज, गुड्स या प्रोडक्ट्स के कारण कंज्यूमर्स एज ए क्लास इफेक्ट हो रहे हैं। हम इस वीडियो में टाइमलाइंस एज वेल एज ग्राउंड्स फॉर द अपील भी डिस्कस करेंगे। सो नाउ लेट अस गो द रेलेवेंट लीगल प्रोविजंस इन द कंज्यूमर प्रोटेक्शन एक्ट बेस्ड ऑन विच यू कैन फाइल एन अपील बिफोर द ऑनरेबल NCDRC। सो हमारे लिए इम्पोर्टेंट पॉइंट इज सेक्शन 24 ऑफ द कंज्यूमर प्रोटेक्शन एक्ट। ठीक, सो 24 के अंडर आपको एक राइट मिलता है टू फाइल एन अपील अगेंस्ट द CCPA ऑर्डर्स, लेकिन जो स्कोप ऑफ द सेक्शन 24 इज़ वेरी लिमिटेड टू द ऑर्डर्स पास्ड अंडर सेक्शन 20 and 21. So if we read again the section 24, a person aggrieved by any order passed by the central authority, which is the CCPA, under section 20 and 21 may file an appeal to the National Commission within a period of 30 days from the date of receipt of such order. So this empowers individuals or entities who feel wronged by the certain CCPA orders to seek redressal from the NCDRC. Why individuals? Because if you see, there are many endorsers, like for example filmmakers are there, influencers are there, social media influencers are there, जो day in and day out products या किसी services को promote करते हैं। So whether they will be liable under the CCPA's orders or not, that is also a part of the scope of section 24 and section 20 and section 21. So if we again revisit section 24, so there are a couple of things which are very critical. A person must be an aggrieved person. Second is, the orders which you can challenge are those orders which are passed by the Central Consumer Protection Authority under section 2021. And third is the period of 30 days from the date of receipt of the order. So now let us understand what are these sections 20 and 21 says. We will break down the understanding of section 20 as well as section 21 into two parts because they also creates our grounds for appeal. Okay, so let's first understand about the section 20. So in section 20, let me read out it for you from the Consumer Protection Act 2019. The section 20 is basically related to the power of the central authority to recall goods or services. What are the conditions under which the Central Consumer Protection Authority can order a company or an individual to recall the goods or the services? Here it is. Where the central authority is satisfied on the basis of investigation that there is a sufficient evidence to show violation of consumer rights or unfair trade practice by a person, it may pass such order as may be necessary, including recalling goods or withdrawing services identified as dangerous, hazardous, and unsafe. The central authority may order recalling as well as reimbursing the price of recalled goods or services to the purchasers. And the central authority can further give an order discontinuing practices that are unfair and prejudicial to the interest of the consumers. So if we look at the section 20, what does that mean is there must have been a investigation, there must have been a sufficient evidence also, okay, which shows that there existed violation of the consumer rights, there existed unfair trade practice by a person, okay. But very importantly and very critical factor is that the CCPA must provide an opportunity to be heard before passing an order under this section. If we now understand, the practical implication is that whenever the CCPA intends to pass an order against you, the CCPA first give you a notice, show cause notice on why the order should not be passed against you. So you will have an opportunity to address the questions, to address the concerns of the CCPA, and if the CCPA is still not satisfied, then the CCPA can give any of the order, recalling of the goods or services or reimbursement of the price of the recalled goods or services, as well as the discontinuing practices that are unfair and prejudicial to the interest of the consumers. But an opportunity of hearing has to be given to you. If you did not receive any notice, if you did not receive an opportunity to be heard before the CCPA, then the order itself gets null and void. So this is where your grounds of appeal are available to you when you receive an order, an unfavorable order, or an order which is entirely against your company. So now let us understand what are the grounds of appeal which you can rely upon under section 21. Okay, now the heading of the section 21 is power of the central authority, that is the CCPA, to issue directions and penalties against false or misleading advertisement. So consumers as a class, when they get affected by these false or misleading advertisements, that's where the role of the CCPA is activated. Now the first four subsections of this section 21 are focused more on what type of directions the CCPA can direct the manufacturers, traders, influencers, or the endorsers. Let's see what are those directions, and we will also now see what are the various conditions imposed on CCPA also to ensure that appropriate directions are issued against the persons who are infringing the consumer rights. Let us understand the subsection 1 first, where the central authority is satisfied after investigation that any advertisement is false or misleading and is prejudicial to the interest of any consumers or in contravention of the consumer rights, it may, by order, issue directions to the concerned trader, manufacturer, endorser, advertiser, or publisher, as the case may be, to discontinue such advertisement or to modify the same in such manner and within such time as may be specified in the order. So first of all, the investigation has to be there, and from the investigation it must prima facie it must come out that okay, this advertisement is false or misleading and is prejudicial to the interest of the consumers, right? Only then the CCPA can issue directions. To whom it can issue the directions? To the trader, to the manufacturer, to the endorser, to the advertiser, or the publisher. Okay, the time should be given, and we will also get to know in the subsection 8 of this section, the CCPA cannot simply give the directions without issuing an opportunity of being heard to any of this person to against whom the CCPA is going to give a direction. So now let us go to the subsection 2. What does it say? Notwithstanding the order passed under subsection 1, if the central authority is of the opinion it is necessary to impose a penalty in respect of such false or misleading advertisement by a manufacturer or endorser, it may by order impose on manufacturer or endorser a penalty which may extend to 10 lakhs, and any further subsequent contravention by the manufacturer or the endorser, the impose a penalty which may extend to the 50 lakh rupees. Now if you see, the penalty can be raised only against the manufacturer or the endorser, not the other trader or the advertiser or the publisher. So the end product manufacturer definitely is going to come under the radar of the CCPA if the CCPA is of the opinion that yes, a penalty must be imposed. The CCPA can impose the penalty up to 50 lakh rupees. Here the endorser will also come into the picture. Who can be the endorser? There are many filmmakers, there are many stars, there are many otherwise influencers who are recommending a particular product or a services for the consumers as a class. Let's now go to the subsection 3. Notwithstanding any order under subsection 1 and 2 where the central authority deems it necessary, it may by order prohibit the endorser of a false or misleading advertisement from making endorsement of any product or services for a period which may extend to 1 year. So now this subsection is only limited to the endorser. The CCPA can send a direction, can issue a direction to the endorser that look, since you have faulted on the earlier endorsement for a particular product, we are now giving you a direction that you cannot endorse any product up to 1 year. Maybe timeline may vary from 1 month to 1 year, but yes, the CCPA has powers to stop the endorsers from who is already held guilty of endorsing the products or the services which has affected the consumer rights and which has affected the consumers as a class. Then the central authority definitely can take an action against such endorsers. Now for any subsequent contravention, the CCPA or the central authority can prohibit such endorser from making endorsement in respect of any product or services for a period which may extend to 3 years. So first contravention, okay, the CCPA may bar the person, the endorser, for up to a period of 1 year, and any subsequent contravention the endorser will have to be barred from endorsing any product or services which may be the debarment may extend up to 3 years also. Let's now understand the fourth direction which the CCPA can issue, where the central authority is satisfied after investigation that any person is found to publish or is a party to the publication of a misleading advertisement, it may impose on such person a penalty which may extend to 10 lakh rupees. So that's here the publishers, will the publishers come into picture? We will see the various defenses are available. But if a person is deliberately publishing such misleading or false advertisements, typically in the YouTube it is happening, right? any publisher, any local influencer, or maybe a high profile influencer is recommending or is publishing the products or services on their own channel, then such publications, such persons can be fined up to 10 lakh rupees by the CCPA. So these first four subsections are defining the scope of directions which the CCPA can issue against the persons who are allegedly involved into publishing as well as the promotion of the false advertisements or misleading advertisements. Now let's see the defenses available. No endorser shall be liable to a penalty under subsection 2 and 3 if he has exercised the due diligence to verify the veracity of the claims made in the advertisements regarding the product or services being endorsed by him. So that's important, due diligence. So many times if the endorser is not having any checks and balances before endorsing any product or services, there are chances that he or she may be under the cloud of subsection 2 or subsection 3 once it is found that a particular product or services was being promoted and various false and misleading advertisements are being endorsed by the particular endorser regarding that particular product or services. Sixth, this is also one of the defense. No person shall be liable to such penalty if he proves that he had published or arranged for the publication of such advertisement in the ordinary course of his business. So that's typically, if you see, this prevents a lot of newspapers, lot of the regular publications from because they are being used as a platform by various businesses for publication purposes, for advertisement purposes. So that's where this will give a defense to the various leading publishers or leading newspapers also. However, please see the proviso of this subsection is provided that no such defense shall be available to such person if he had previous knowledge of the order passed by the central authority for withdrawal or the modification of such advertisement. So if there is an order, existed order of the CCPA to either withdraw such advertisement or to modify such advertisement, and still after that the publication was found in particular publication company, then they cannot invoke the defense under subsection 6. So then another subsection, another defense available. While determining the penalty under this section, regard had to be the following, namely, first, the population and the area impacted or affected by such offence, the frequency and duration of such offence, vulnerability of the class or persons likely to be adversely affected by such offence, and gross revenue from the sales affected by virtue of such offence. So the penalty, the CCPA cannot impose a penalty in an arbitrary manner. At least the CCPA has to consider points A, B, C, D while determining the penalty amount against the endorser or the manufacturer. And finally, very important, which is definitely one of the main criteria to ensure that principles of natural justice are always followed, the central government shall give an opportunity of being heard before an order under this section is passed. So now if you look at this section 20 as well as section 21, so various defenses, various grounds of facts as well as grounds of law are available to the appellant, so that the appellant can file an appeal before the Honorable NCDRC based on these grounds, which are the grounds of the facts or the grounds of the law. So having said that, when you should move the appeal against the CCPA order? Answer to this question is 30 days time period. Okay. Now section 24 clearly and categorically says that it is the 30-day timeline within which the aggrieved person has to approach the Honorable NCDRC, okay, to file an appeal. See, unlike in the first appeal or in the second appeal or in an appeal against an ex parte order of the State Consumer Commission, the relevant sections actually disclose that the aggrieved person or the aggrieved party can file the appeal beyond 30 days timeline also, provided there existed a reason of sufficient cause has to be addressed before the Honorable Commission to seek the extension beyond 30 days. But if we look at the section 24, there is no such proviso available. So our point of view on this timeline is that again these 30 days timeline, if we look out for the overall objective of the Consumer Protection Act 2019 and various regulations made thereunder, so we still feel that this 30 days time period under section 24 is not a mandatory, but it's a directory in nature. But definitely one needs to convince the Honorable NCDRC bench who is going through this appeal if you have delayed beyond the 30 days timeline. So once you prepared the grounds of appeal, once you are also within the time for filing the appeal, what happens before the Honorable NCDRC? So typically what happens is that you filed the appeal, and obviously now the opposing party, it's the Central Consumer Protection Authority itself, and the notice will be issued to the authority, and if they wish to file the reply can be filed on board. And if you wish to file the rejoinder, then the time for rejoinder is given to you, typically 2-3 weeks from the date of receipt of the notice. The reply can be filed, then again from the date of receipt of the reply, the rejoinder can be filed within 2-3 weeks, and subsequently the matter would be listed for the final hearing. And as of now, the practice before the Honorable NCDRC is that you file the judgments, you file the brief synopsis, and prior to the final hearing, and once the matter is listed for the final hearing, the arguments are heard, and the matter is then the matter is reserved for the orders, and that's it. If we go by the statutory timelines, the appeal must be disposed within a 90 days timeline, but generally it takes time. You consider 6 months to 1 year time period for the final adjudication on the appeal proceedings, and that's how the overall brief process about the NCDRC hearing procedure for CCPA appeals. So let us also understand what happens after the final decision is given in this CCPA appeal by the Honorable NCDRC. One aspect to look out is that if you do not challenge this order further, then the order will be attained finality if there is no further appeal made against it. So whether do you have really option to file an appeal against the CCPA appeal or not? If we park that issue side as of now, the next option could be, if you are still aggrieved by the NCDRC order in the CCPA appeal, then obviously you can attempt for filing a review before the Honorable NCDRC. That has to be filed within 30 days from the date of receipt of the order. And in case you are not interested in filing a review, the other options available to you is that you can approach the Honorable Supreme Court by filing a SLP, or you can also, if you find perversity in the Honorable NCDRC order, then you can also approach your respective High Court also, from where the cause of action has arises, because as of now the CCPA office is in Delhi, and so primarily Delhi High Court may come into picture, but there might be chances in the future where the CCPA has the various commissions which are operating from different parts of the India. So that's where the other high courts will also come into the picture. So you can also invoke Article 227 to approach the Honorable High Court against the honorable NCDRC order. So that's pretty much sums up about the post appeal scenario. And if we conclude the today presentation, primarily section 24 is the section from where you get a right to file an appeal against the CCPA order, but you have only options to file an appeal against the orders which are passed under section 20 and the section 21. And finally, 30 days filing deadline is important for you to ensure that your appeal is listed before the honorable NCDRC without any procedural or the technicalities. I hope this video would have helped you to understand the scope of the CCPA appeal, when you can approach the honorable NCDRC for filing the appeal, and as well as what will happen after you are aggrieved even by the NCDRC orders, where you can approach. And don't forget to share this video with your friends or with the business companies who are involved into the B2C categories and who are facing a consumer dispute or maybe an adverse order from the CCPA. This video would help them to exercise their right to file appeal against the adverse CCPA order. And if you have any questions or specific queries, you can put your questions or queries in the comment box, or you can also email to us. We will try to send reply to your specific queries. And do subscribe to this channel. We have also created a lot of other consumer rights related videos that would help you to understand the scope of the Consumer Protection Act, as well as the various rights as of the complainant as well as of the opposite party. And thank you very much for going through this video. Jai Hind.